Hello, everyone. I'm Justine Del Preti. I'm from the Wright Insurance Group, and I'll be your host today. Along with me to present the Managing the Risk of a Dry Campus is going to be Dirk Patrick, ESQ. He works for Nelson, Levine, DeLuca, and Hamilton. We're happy to have him with us today. And we also have a Senior Vice President of Wright Risk Management, Bob Bambino, with us as well, who will be speaking briefly. So I'm going to pass it over to Dirk.
Good morning, everyone. Thank you for that introduction, Justine. We're going to talk a little bit this morning about, as the topic suggests, managing the risk of a dry campus. And I'm going to primarily focus, at least initially, on some of the legal aspects that you may not be aware of and some of the current trends that we're facing with respect to, from a legal perspective, what does happen when you do decide to go dry on campus, and some of the fallout that can happen, at least from a legal perspective. So let's take a look at the next slide. As I talked about, this is something that a lot of you may not fully be aware of, that when you do adopt a zero-tolerance alcohol policy, that it actually may create a higher duty of care to protect and give the university or college an even higher exposure than campuses that do allow alcohol on campus. And that may seem a little counterintuitive because you sound like you're doing something that is going to protect you or insulate you further from liability exposure. But as we'll see this morning when we go through some of the case law that has addressed this, it actually can sometimes have the exact opposite effect. So this is what we were talking about. By adopting a zero-tolerance alcohol policy, and this is critical from the legal perspective, that if you really think about it, when a university or college decides to adopt a zero-tolerance policy, they're really acknowledging two critical legal points. The first being that alcohol consumption is a serious problem on campuses that needs to be regulated, and the second key point to recognize is that the best solution is to completely prohibit. Now, normally those are issues that plaintiffs in these types of cases that are coming after colleges and universities will try to establish. But once you adopt that policy, you're essentially already setting the foundation, at least from a legal perspective, and we'll talk about what can create a duty. So these are critical points that when you do adopt a zero-tolerance alcohol policy, from a legal foundation perspective, it creates a certain duty. And let's look at the next slide and talk about that. As we talked about, the approach of adopting the zero-tolerance policy can be problematic because you assume a duty. And as we're looking at on this slide here, it's analogous to a Good Samaritan. Once you take an action, and the action here being agreeing to adopt a zero-tolerance policy, that you assume certain duties and you have to act reasonably. And as we talked about, if the best solution is to completely prohibit alcohol consumption, institutions must have legally sufficient policies or procedures in place. So it's like we talked about, it's the same thing with a Good Samaritan. If you're driving down the street and you see someone that's in danger or distress, you don't have to stop. But if you do, you have a duty to act reasonably when you do attempt to assist that person. And it's the same thing. You don't have a duty to adopt a dry campus or a zero-tolerance alcohol policy, but once you do, there are certain things now that you have assumed as a duty that you have to follow through, use reasonableness, and make sure that you adhere to. So let's look at some of the challenges that institutions that act as those Good Samaritans, so to speak, and adopt a zero-tolerance policy. So let's look at these challenges. And many of you may already be aware that currently a third of all American campuses are now dry. It's a very large number, and it's why I think a lot of the plaintiffs' attorneys now are starting to focus on this as being a basis for assumption of a legal duty. So what's the problem? You know, the problem, as we all probably know, is that regardless of the rules, whether there's a zero tolerance policy, college-age students, many of which are underage, simply drink. Let's go to the next slide. Now these are just some statistics that just show what the current landscape is, which again I think most of you are probably already aware of, but just to highlight what the problem is, or what the current landscape is with institutions that have decided to ban or have a zero tolerance policy. This is from the Harvard School of Public Health College Alcohol Study, a recent report. It said that students at dry campuses were less likely to binge drink and more likely to abstain from alcohol. However, students who drink at these colleges drink just as heavily as students in non-banned schools. So there's still the endemic problem of drinking. Regardless of whether that policy has been instituted or not, it's still a problem. Students are still drinking heavily. So that brings us to the next point. Banning alcohol on campus and doing nothing else would be the policy equivalent, and this was according to the CSA study, the policy equivalent of sweeping all of the spilled beer at fraternity parties under one giant rug. And that's really what the theme that we're talking about here is, that it's not simply enough to say, yes, we've adopted a zero alcohol tolerance policy, it's banned on our campus, we don't allow it. That's simply not enough. In fact, if you do that, that creates what we talked about, the possibility that you've assumed a duty to do more. So let's go to the next slide and talk about what some of those duties may entail and some of the problems that you're facing. And these were just a few quotes. I just randomly looked on the internet for blogs from different organizations, and also from articles that were on the internet from students at dry campuses, and it was overwhelming, the information and the articles that I was reading from the students. And I just highlighted a few of the things from some of those articles and blogs. And it's the same thing we hear. I can choose the next leader of the free world. I can destroy my lungs by smoking cigarettes. I can be subject to the death penalty, can pay thousands of dollars for my education, get a loan, do everything, yada, 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 but I can't have alcohol on campus. Does this make sense to you? Now, this is the student perspective, and again, these are articles from students at campuses that are dry and have adopted a zero tolerance policy. So despite that policy, this is the challenge you're facing. This is how, unfortunately, it appears that many, if not the majority of students on those campuses, underage students, mind you, also feel. So despite the fact that the policy is in place, these students they're not on board. The majority of them do not feel that it's justified. And the end result is the majority of them are not adhering to it. And here's some more from the student perception. I hate to break it to university officials, but no matter how much they try, no matter how many policemen are on the streets, and no matter how harsh the consequences, there will always be students consuming alcohol. It is a fact of college life. There's another one. The majority of students are clearly not following the alcohol policy. Students do not feel obligated to follow the alcohol policy and do not feel threatened by punishment for violating the alcohol policy. And this is a very telling. This was a statement from a student at a dry campus. The rules in place are hardly known, let alone enforced. So therein lies the problem. For universities that have adopted this higher legal standard, admitted that there's a problem, and admitted essentially by adopting the policy that the only way to address it is to completely ban it, and then you have students with this type of attitude with respect to that, it's a recipe for disaster. Let's go to the next slide. So let's look at some of the, what we were talking about earlier, some of the legal trends and some recent case law that deals directly with zero tolerance policy regarding alcohol consumption, and the university having no knowledge of the activity. Now, I've kind of led into this, but I think a lot of you, if I just made that blanket statement to start out, if you as an institution have a zero tolerance policy regarding alcohol consumption and you have no knowledge of any alcohol consumption on your campus, you would probably think that you're insulated from potential exposure. Well, as we'll see from some of the next slides, and we look at some of the cases that have directly addressed this issue, it's not the case. So did you know that, and this is what we talked about before, that some jurisdictions impose a heightened legal scrutiny when examining institutional policies prohibiting alcohol consumption? And again, that may sound very surprising to some of you on the phone, but if you don't do anything, you may actually not have as much exposure as those institutions that take this additional step and try to ban the alcohol. And that's for that legal duty reason that we talked about before, by acknowledging that it's a problem and further acknowledging that the only way to address it and correct it is to ban it. So let's look at some of the current legal trends facing higher education institutions arising out of alcohol consumption. Now, this is a very interesting case, Flynn versus Fairfield University. Came out of Fairfield University in Connecticut, obviously, and the injury was a traumatic brain injury, a very serious injury from an underage student that was injured in a motor vehicle accident. The driver of the vehicle was an intoxicated student who had been drinking in his dormitory at a dry campus, Fairfield University. Let's go to the next slide. So the liability theory, and this is what we were talking about before, is that in this case, they used that the dry policy, the no tolerance standard, to articulate this legal theory. This was the plaintiff's legal theory, that the university negligently permitted students to keep and consume alcoholic beverages in dormitory facilities in violation of school policy and Connecticut law, and also that the university failed to monitor possession of alcoholic beverages on campus or to provide sufficient security personnel to ensure the safety of the students. So this is exactly what we were talking about. Once you've agreed that the problem exists and the only way to address it is to completely prohibit it by having a dry campus, this is the type of arguments that you're opening yourself up to, that you've acknowledged it's a problem, therefore you have a duty to correct it. Let's go to the next slide. And this was the legal standard that the court in that particular case adopted. And as when I read it to you, you can see that it's so broad and so overly encompassing that it's almost impossible to not have potential exposure if this is the standard that's applied. The question is whether the ordinary person, knowing what he or she knew or should have known, would anticipate that harm of the general nature suffered was likely to result if care was not exercised. That's as broad a standard for creating a legal duty as you will probably find. So you can see how this framework is structured. The university has acknowledged it's a problem, drinking, because they've adopted the policy of no tolerance. Therefore, they have to do something to make sure that kids are not violating this policy. And if unbeknownst to them, they somehow do, or one of the students does violate that policy, then potentially the institution is on the hook. And that's when the reasonableness of their actions. So just burying your head in the sand and thinking that you've adopted this policy insulates you, it's the exact opposite. That's the legal standard, and everything that you do to enforce that policy is now going to be examined and scrutinized. And in this particular court, see what the court ruled, that the foreseeability test that we were just talking about with the duty standard and the reasonableness was met in this particular case because of these bare facts. It was the students who drink to excess and then drive automobiles on a public highway pose a danger to themselves and to others. This fact is recognized in the university handbook and by university employees. Okay. Pretty much hard to argue with that statement. The court then pointed out the fact that the sale and consumption of alcoholic beverages is closely regulated and it's prohibited by state statute. And this is the key, the third point, and we'll see this in many cases, and courts are starting to kind of use this as a fallback, that universities accept tuition monies and provide dormitories to those who pay room and board. So by virtue of accepting tuition, adopting a no-tolerance policy, courts are essentially saying, you've locked yourself in. Once you do that, and we can come up with these very broad standards, we can say that the reasonableness or the foreseeability exists because you know about the potential danger involved and you accept tuition and provide dormitories to these students that pay you, then there is a legal duty. And you better make sure that you've done everything to make sure that you've acted reasonably or there's potential exposure. Let's go to the next slide. This is another case. It was Coughlin versus the University of Idaho. And this one, it was the plaintiff sustained very serious personal injuries when she fell from a fire escape after getting intoxicated at a fraternity party. So let's go to look at what the court actually, again, a similar liability theory in that case, that it's all this assumption of a duty to protect students by implementing an alcohol monitoring policy or procedure. So that's what we talked about at the outset, the heightened duty that you accept when you adopt these policies. At least that's what the plaintiffs latch onto when they're trying to create. And remember, for a case to proceed, there's kind of two steps. You have to establish that as a matter of law that you have a legal duty. And that's a question. That's when you hear about a motion for summary judgment that the courts will rule on. And if the court or the judge determines there's a legal duty, then the case goes to a jury. And that's when, as we all know, anything can happen. So this is a pivotal point. If courts decide as a legal matter that the institutions have a legal duty, essentially simply because they adopted these standards, then you're almost always guaranteed if something happens, it's going to go to a jury and anything can happen. So let's go to the next slide. And this was an interesting holding in this case as well. It said that university employees knew or should have known that alcohol was being consumed by underage students. Again, what we talked about, once you adopt the zero tolerance policy or go dry, you've acknowledged that it's a problem. So that's what the court ruled here. The second point that the court said was that the university assumed the duty to exercise reasonable care to safeguard the underage plaintiff in that case from the criminal acts of third persons, i.e. furnishing alcohol to underage students. Again, the same general theme as the last case we were talking about. Let's look at the next slide. This is another case that had some very interesting language that plaintiffs are trying to latch onto, and it's a kind of a scary case. You know, the facts here was that the student filed suit against the college for injuries she sustained when she was raped on campus while intoxicated. So let's go to the next one. Again, we talk about, and this is that critical, you know, do you have a duty? Can you be held in a case? Can you not get out on a motion for summary judgment because you have a legal duty based upon adoptance of certain standards? In this particular case, the duty that was argued was, and this is what the court said, that duty finds its source in existing social values and customs. A duty voluntarily assumed must be performed with due care. Let's go to the next slide. And again, these are such, you know, vague legal standards that these courts are creating that they're going to almost be always all-encompassing. And essentially what the court held in that case was, you know, the plaintiffs had a expert that visited 18 other colleges and said that they had all different types of security to protect against these types of incidents, and therefore this institution potentially could be responsible. And the language at the very end is interesting. It said, you know, this recognition indicates that the imposition of a duty of care is firmly embedded in a community consensus. And really what I was trying to do is just highlight some of the language that courts use to kind of just throw this general umbrella, so to speak, over institutions if they want to find a legal duty. And that's about as vague as you can get when you say it's just embedded in a community consensus. So let's go to the next slide. And this is what the court further went on to say, that the general community has a reasonable expectation, fostered in part by colleges themselves, that reasonable care will be exercised to protect resident students from from foreseeable harm. What does that even mean? Let's go on and the next point on here. We'll go to the final one, and this is, no, could you go back to the prior slide? There you go, thank you. And this is really what we're seeing courts start to grab onto, and it's what we talked about in that first case with accepting the tuition. And this was exactly what the court held here. And let's read this, because I think some of you may be surprised that this would be enough to create a legal duty when arguably you did nothing wrong. But the court said it is quite clear that students and their parents rely on colleges to exercise care to safeguard the well-being of students. When students are considering enrolling in a particular college, they are likely to weigh a number of factors. But a threshold matter is whether the college is undertaken to provide an adequate level of security. Thus, prospective students and their parents who visit a college are certain to note the presence of a fence around the campus, the existence of security guards, and any other visible steps taken to ensure the safety of students. They may inquire as to what other measures the college has taken. If the college response is unsatisfactory, students may choose to enroll elsewhere. So in essence, what the court is saying here is that simply because you enroll students and take their money, you have this duty that's essentially non-ending. And anytime something goes wrong, you're going to at least have to go to a jury if this standard is adopted. So let's go to the next, and it was adopted in that particular case. And we talk more specifically, this was another very interesting case that's also been cited in more recent cases that are trying to prosecute these types of claims. It was the Furyk case, which it was in a hazing incident that happened at the University of Delaware. Pledge brought suit for injuries when he was burned as part of a hazing incident or stunt. They poured oven cleaner on his body, and he sustained serious injuries and burns. Let's go to the next slide. So the legal question in that case, and this was a case where it was really a very monumental decision where, courts for one of the first times started stepping past or finding loopholes to traditionally what courts had said is that, universities don't stand in this, loco parentis relationship to the students, and therefore they're not responsible for their behavior. But what the court said here was that, we here confront the broad question of whether the law imposes upon the relationship between the university and student a duty on the part of the university to make and enforce policies which might protect the student from harm occasioned by the acts of third parties who function under the auspices of the university. So that's an interesting way that the legal issue was framed. And what the court held there, and it was a very important holding, was that certain established principles of tort law provide a sufficient basis for the imposition of a duty on the university to use reasonable care to protect resident students against the dangerous acts of third parties. While we acknowledge the apparent weight of decisional authority that there is no duty on the part of a college or university to control its students based merely on the university-student relationship, where there is direct university involvement in and knowledge of certain dangerous practices of its students, the university cannot abandon its residual duty of control. And that's what we talked about at the outset. And traditionally, colleges and universities were not deemed to have control over their students based merely on that relationship as an institution and a student. However, and Furyk opened the door to this, that what the court was saying is that if you do take that extra step and do enforce some type or adopt some type of policy or procedure that you perceive as protecting the student, such as a zero-tolerance policy, everything we talked about before, then guess what? It's no longer just a university-student relationship. You have now adopted and acknowledged that there are dangerous activities on your campus, and you've also acknowledged that you have to prohibit it to protect your students. And by doing that, under this holding and under this type of legal theory, you now have a duty. you now cannot hide behind what once was this shield to protect you and say that you don't have control over the students simply based on the university-student relationship. Now, and pursuant to the holding in Furyk and pursuant to some of the other cases that we looked at, a very, very persuasive argument can be made that guess what? Now circumstances have changed and you do have a legal duty because you've acknowledged the problem and you've also adopted a policy or procedure to protect students. So let's go to the next slide. And this is what we talked about. The rationale behind it, and this was what the court said, was that the evidence in the record strongly suggested that the university not only was knowledgeable of the dangers of hazing, but in repeated communications to students in general and fraternities in particular, emphasized the university policy of discipline for hazing infractions. The university's policy against hazing, like its overall commitment to provide security on its campus, thus constituted an assumed duty which became an indispensable part of the bundle of services which colleges afford their students. Now, that's pretty shocking holding or rationale for that holding when you think about it, because what the court was saying is that, look, even if you didn't know this was going on, even if you did enough to prevent it, we're going to say you had a legal duty, and this has to go to a jury for the jury to determine whether you're liable, because you recognize that there was a problem with hazing, you recognize the dangers of hazing, and it's the same thing with alcohol consumption, and you repeatedly put out these statements and policies to fraternities in particular that, guess what, we prohibit hazing, it's dangerous, we will not allow it. And what did the court do? Instead of saying those were great things that the university did to prohibit it, they said, guess what, you're now on the hook for this hazing incident potentially because you took that affirmative step to acknowledge that it was a problem, and you also sent out these repeated communications saying that it was a problem and saying that it needed to be prohibited. So essentially the court was saying is that if you would have done nothing, then you hadn't assumed that duty. But since you did acknowledge the problem and adopt a policy and warn against it, somehow now you're on the hook or potentially could be on the hook from a liability perspective, whereas if you had sat back and done nothing, you would be okay. So let's look at the potential liability exposure. This is another interesting, more recent development that is particular to campuses or institutions that have adopted dry campus policy. And is there potential liability exposure for importing or forcing students to go off campus and drink? And this was a really interesting case. It was also at Fairfield University, the McClure case. And this was a situation where the student again, it was personal injuries, serious personal injury that was sustained in a motor vehicle accident. And the plaintiff actually was injured when he was returning home from a popular off-campus drinking location. It was a beach area where a lot of students would go to drink. A lot of underage students would go to drink. There were a lot of students that lived in that area, and it kind of became known, at least locally, as the area, since alcohol wasn't allowed on campus, that the kids would go drink. So let's go to the next slide and see what happened here. So the legal theory in that case was, although this incident occurred completely off campus, the alcohol policy for that university at the time arguably did not apply to that area, so you would assume that the university had no potential exposure, no responsibility for this. But what the court said was that, back up please to that prior slide, what the plaintiff argued was that the university was negligent and that it failed to enforce rules regarding alcohol consumption and to provide adequate transportation to students between the campus and known off-campus drinking destination. This is what the plaintiff tried to argue, that, okay, if it's not just okay for you to ban it on your campus, but if you know that students are leaving your campus to go drink somewhere, you now somehow have a duty to make sure that they have safe transportation. Sounds like a wacky legal theory, but let's look what the court decided on the next slide. And these were some of the key allegations that we talked about. It was really just that these kids were living down in that beach area. They were drinking there. The school arguably had knowledge of this, or interestingly, what the court says, what the school could have found out about this by just checking police blotters and things of that nature. So even if they didn't actually know, what the court said, and the plaintiff tried to argue, was that they could have found out had they taken any reasonable steps whatsoever. So let's go to the next slide. So again, this is what we talked about. You know, the key allegations in this particular case was that, you know, while the university had this alcohol policy and applied to all students, it didn't attempt to enforce that policy on students that were going down to drink in that beach area. And the plaintiff also argued that, you know, the university's strict enforcement of the drinking age on campus, but it didn't do that down in that beach area, actually encouraged the students, as we talked about, to go and drink in the beach area. And for those reasons, the plaintiff argued that it was foreseeable that this incident would happen, and therefore the university had a duty to protect that particular student. Let's go to the next one. Go to the prior slide. So, and this was just an amazing holding in this particular case that really kind of shows you what the landscape can be and what you're facing when you think you're really doing the right thing by adopting these policies. And I'm certainly not trying to send the message that you shouldn't, and we'll talk about that at the end. What I'm the message or the theme here is that if you do adopt these policies and you have adopted these policies, that you really can't just bury your head in the sand and think that's enough. You have to take very proactive measures. So what was the holding here? Again, the university-student relationship is certainly unique. While its primary function is to foster intellectual development through an academic curriculum, the institution is involved in all aspects of student life. Through its providing of food, housing, security, and a range of extracurricular activities, the modern university provides a setting in which every aspect of student life is, to some degree, university-guided. This attempt at control, however, is directed toward a group whose members are adults in the contemplation of law and thus free agents in many aspects of their lives and lifestyles. Despite the recognition of adulthood, universities continue to make an effort to regulate student life, and the courts have utilized diverse theories in attempting to fix the extent of the university's residual duty. So again, what they're focusing on is that once the universities start to try to regulate any aspect of the students' lives by adopting a zero-tolerance policy, that now you've stepped into that assumption of a duty, and you better make sure that what you're doing is adhering to all of the reasonableness standards to make sure that you're enforcing this policy, or you're going to potentially have liability exposure. Let's go to the next slide. And again, and that's exactly what the court held here. It said that student alcohol use has become an increasingly serious problem in recent years. The university has acknowledged this, and that it has an anti-alcohol policy that applies to all underage students. While the university had knowledge that underage drinking frequently occurred at the beach area, it did nothing to enforce the policy there, which indirectly encouraged students to go to the beach area in order to drink alcohol. Go to the next slide, please. So what do we learn from this? I mean, what's the general theme? It's what we were talking about, that, you know, it's a great thing. It's a problem throughout the country, drinking on college campuses. Certainly there's more than enough data, studies, and statistics to show that a zero-tolerance policy or a dry campus mitigates potential accidents. However, conversely to that, the adoption of these policies, they will, and courts are doing it more and more, the courts will determine that by doing this, you've acknowledged the problem, you've adopted a policy, and once you've done that, you really better make sure that you're doing everything to show that you're reasonably enforcing it. And it's not simply enough to say that we have this policy or we have this procedure. We mandated that it was prohibited, therefore we shouldn't be responsible. That's not what the courts are saying. In fact, the courts are saying the exact opposite. And when you put that in the context of earlier when we looked at some of those statements from the students at dry campuses, we know they're violating the policies. We know they don't believe that they're enforceable or that they shouldn't even exist. So this is creating, at least from a legal perspective, a potentially very problematic and dangerous legal scenario when you have a policy or procedure, you know students are violating it, the majority of the students don't agree with the policy, and therefore the courts are saying you're going to have problems if there's an unfortunate incident on your campus. So what can we do? I think we've highlighted the problem or the issue, and that's what I was hoping to really accomplish here today, to make everyone aware that this is a serious issue, and if there is a serious accident at your institution, that there's problematic legal issues, and that you better make sure that you've done certain things to show that you acted reasonably and you can't just fall back and think you're afforded protection because you banned the consumption of alcohol. So what can you do? And we'll just touch on these. These fall more into the risk management category. But clearly it goes down to, the two things that you hear all the time, training and enforcement. You need to make sure that your people on staff have the training they need and that they're enforcing when there's prior incidents, because that's where there's always issues. If the university knows or should have known of prior incidents, you have to make sure that there's sanctions, there are proactive measures that are taken. And this is an interesting statement that I found when I was preparing for this presentation. It said the best defense an institution can present is to demonstrate it has made every effort to put in place evidence-based practices, said William DeJong. He's the former director of the U.S. Department of Education's Higher Education Center for Alcohol and Other Drug Abuse. And this is what he said: if you don't do that, then you're obviously in a weakened legal position. So you really need to think about what are the best evidence-based practices that your institution can have in place so that if you do have one of these unfortunate incidents occur, that you're not simply relying upon, hey, we had this policy in place, they knew they weren't supposed to do it, therefore we're not responsible, because guess what? That's probably not going to work. You're going to have to fall back and establish that you did have these evidence-based practices in place and that you were attempting to educate, train, and enforce your policies and procedures. So let's go to the next slide and look at that in a little more detail. So what can you do? And there's a couple of weak links that are obvious. Your RAs, your resident advisors, and the campus security. They're two very challenging positions to have on a college campus when alcohol consumption is a acknowledged serious problem. RAs have a tremendous amount of peer pressure, and frankly, campus security, it's difficult to monitor just because of the sheer volume of occurrences that take place. So let's look at the next slide. So we talked about, RAs are in a very, very difficult position, and I've seen many cases where that really does become the focal point of the plaintiff's case, that the RAs either didn't have the proper training and or they gave in to peer pressure. They knew that students in their dorm were drinking. They let them slide because they were their friends. It's a serious problem, and it's a serious weak link when you have these types of cases, particularly if you have a student that gets intoxicated in a dorm and then goes out, and whether it's in an automobile accident like we saw from some of those other cases, or any type of incident where there's going to be a serious injury, the RAs are that weak link. What were they doing? And what you'll find when you depose these RAs is that, oh, well, I didn't receive the proper amount of training. So what always happens in these cases when you start litigating them is that the people that really drop the ball always try to fall back and say, well, I was never really told. I wasn't given enough education. I wasn't given enough training to have this position. And, a lot of plaintiffs' attorneys that I deal with even are trying to develop this theory that these 18, 19, 20-year-olds should not be put in a position to try to manage risk management issues because they don't have the age and experience. So it's a flawed system, so to speak. But the point being that really all you can do to protect yourself and mitigate exposure in this area is you have to make sure that you really do have very specific, very focused training policies and procedures in place, and that there's routine checkups, there's routine ongoing educational training for the RAs so that you can show that you did do everything to give these individuals the tools they needed to be able to perform that function and their jobs properly. Let's go to the next slide. Again, we talked about, the RAs being your weak link, and, this is a quote from an RA. The alcohol policy is the hardest line for RAs to walk, especially when a good portion of RAs use alcohol leisurely because it serves to distance the relationship. The situation leads to a lot of RAs to openly discuss drinking and even turn a cheek when someone they're becoming close to is using it. It's a policy with a lot of gray area for RAs to apply at will. And that's really the issue. And so if it's a gray area for these RAs, that's where the training needs to focus. You need to make sure that, and there's no way to guarantee, and obviously it's going to happen, but as long as you've highlighted that and provided training and the RAs are aware of it, then it's a much more difficult argument for the RA or a plaintiff's attorney to make that you didn't tell them about this or they didn't know what they were getting into. Let's go to the next slide. And the second thing we talked about, campus security, that's really your first line of defense. And that really needs to be something that you focus on in these alcohol-related cases. There really needs to be a coordinated effort between campus security, between whatever agency that you have set up to monitor Greek life, Greek activities on your campus, and the students. There really has to be a coordinated effort between all of those entities to make sure that you're doing everything you can to enforce these policies and procedures. And we know it can't be eliminated. We know it's going to happen, so what you have to do is just establish what you did was reasonable. So you need to extend the code of conduct beyond the immediate campus. That's what we talked about. We saw in the case involving the beach. But again, it's that slippery slope that the more you do, the more responsibility you're biting off. So again, if you are going to extend that conduct beyond the immediate campus, which many institutions do, that opens up that potential exposure we saw in the beach case. Well, if you're doing that, do you have some policy or procedure in place where you're checking police blotters, where you're doing some type of investigation to see if this conduct is being, that the code of conduct is being breached or violated off campus? What measures, policies, or procedures do you have in place to monitor that? Because you can see the argument a plaintiff would make if you do have that policy in place, you do absolutely nothing, something happens, you're in a deposition. Well, what did you do to make sure, or to even try to find out whether the code of conduct was being violated at a beach area or wherever the local drinking destination may be? And if you don't have good answers to those questions, it's going to be an uphill battle from a legal perspective. Don't just try to, this ties into that prior point, don't just try to keep alcohol out of the residence halls. That's a very insular approach, and if that's all you're doing, it's not going to be enough, as we saw in those other cases. And presence equals deterrence, and it's something that whether it's an RA, whether it's campus security, whether it's someone positioned in the residence halls to make sure that alcohol is not coming in, whatever it is, just make sure, and there's a myriad of different approaches to this, but just make sure that you do have an approach, and you do have a comprehensive approach. You have an approach that's coordinated. Let's go to the next slide. And again, just some more tips, and I'm only touching on these very broadly because, in actual practice there are, again, a myriad of different approaches to this. I just want everyone just to kind of highlight to make sure that you're aware that you do need to have at least some type of approach, and these are some of the suggestions that if you do have alcohol monitors, make sure that you have the adequate personnel that they're properly trained, and that they have the authority to actually do something. I was involved in a case where there were actual alcohol monitors that were in use, but the plaintiff was able to really get a lot of traction from the fact that most of the alcohol monitors that were being used by the university were very young females, and when we started deposing a lot of them, they admitted that they were told, not only were they told, they were also afraid to actually, if they saw parties going on at fraternity houses late at night, that they were intimidated by that situation, and as a young female, they would not have put themselves into that situation to go in and find out what was going on. Well, of course, you can see the plaintiff was like, why in the world would you have those types of alcohol monitors then when clearly they're not able to perform that function? So it's just something to think about. It's simple, but you really just need to make sure that the approach, the policies and procedures that you're putting in place make sense, and they are as effective and they are as reasonable as they possibly can be. Again, just a couple training solutions. You know, tips for RAs and Greek officers. This is something we, as defense attorneys in these cases, we get a lot of mileage from, because as I talked about before, it always seems to be the case that when the weak link, the person that didn't do their job, is under the spotlight, they try to throw the institution under the bus and claim they did not have proper training. The plaintiff's attorneys try to attack that prong because it's difficult to defend against. So the more things that you can have in place as an institution that objectively show that these individuals had very specific, very detailed training that deal with alcohol, then that's a much more difficult argument for the plaintiffs to prevail on. And you know, the TIPS training, it's called RAMP in some jurisdiction, TIPS in others. It's just an alcohol training course that's very comprehensive. Make sure that RAs and Greek officers have this training. That can really protect you in these types of situations. You know, MAD for students in the resident halls, and then I don't know how many are familiar, many of you may be, with the alcohol EDU and what's now become the Greek Life EDU training programs and modules. They're great tools. They have a lot of good information in them that's good not only for educating the students, but they're great from a defense perspective when you can show those videos that are in some of those modules that warn and show you exactly what you're not supposed to do, and the students, the RAs, the Greek officers have actually gone through that training and seen those modules. It makes that argument much, much more difficult and really can protect you from a defense perspective. Let's look at the next slide. So what are some of the administrative solutions? You know, these are things that, you know, I see come up in a lot of these different cases, and these are things that mitigate. There's certainly things that can help you show that, you know, although there's no policy or procedure that's going to be 100%, we know that there are going to be violations, and so it goes back, the legal standard is, well, what did you do to show that you were reasonable in your approach? And these are some things. Just, you know, make sure that at your institution you have a specific individual, that's the Director of Alcohol and Other Drug Initiatives. That's one of the titles that's used pretty universally, but make sure you have an individual that's responsible for coordinating all of these different issues we've been talking about. And that person becomes a very pivotal point person if one of these cases do arise. That person needs to be responsible for making sure that these programs are in place, that they're coordinated. And I cannot emphasize enough, I really just want to try to highlight that it's not enough to just have these policies or procedures in place. You have to show that you're doing something. There's oversight. There's analysis of what's working, what's not working. There's actually someone that's looking at this, that's making sure from a risk management perspective that not only do you have the policies and procedures in place, but you're making sure that they're working to the best of your ability. Another one, a vice president of student life. And this is another, I don't know how some of you may be familiar with the National College of Health Improvement Program. Just want to put that out there. That's the NCHIP. It's a great resource with a lot of salient information on this point. For those of you that don't know, it's an Ivy League initiative that collects and shares data on best alcohol prevention practices. That's something if you want to look up on the internet. There's a lot of great resources, and something that you may want to start collectively thinking about as institutions, as an overall policy or procedure that you may want to adopt that really helps all the institutions kind of come together, share their experiences, share their knowledge. What are they doing that works? What are they doing that doesn't work? And it has a two-prong effect. I mean, first and foremost, we want to make sure that our students are as safe as possible, and that's what that does. But also from a liability perspective, it goes to that duty issue. What are you doing, and was what you were doing reasonable and enough? And if you can show that you were sharing, not only adopting these policies, putting all these policies and procedures in place, attempting to make them work, but also sharing them with other institutions to find out what really was working best, you put yourself in the best possible position to defend one of these cases. And that kind of goes to what the key takeaway that I hope everyone on the phone is coming, getting this key takeaway. It's that you have to be proactive, not reactive. If you wait till one of these incidents happen, you're going to be in a very difficult position. And if you just think that, okay, we've adopted this policy, we've told our students in our student handbook, no alcohol, therefore we're protected from a liability perspective, I think you're going to be unpleasantly surprised if something bad happens, given the climate of the legal landscape out there and what's going on. So, and really it's an all-encompassing approach that's best for the students. It's what will make the students as safe as possible. Hopefully one of the incidents like this don't occur, but if they do occur, you know as an institution that you've done everything possible to prevent it, and there's nothing that you did wrong or that you came up short so that you would be exposed to liability for the unfortunate incident. So that's my presentation for this morning. If anyone has any questions about anything, my email and my phone number are on the final slide. I hope everyone has found this educational, and again, just wanting to highlight, please be proactive if you have these policies. Make sure that you're coordinating your efforts. Make sure you're doing everything you can to protect your students and also protect yourself.
Thank you so much, Dirk. We really appreciate you coming here today and discussing the duty to care. I think it was a really great presentation. I just want to let all the attendees know, if you're still on, if you want to ask any questions at this time, I will be able to take them. Just click your chat button, send them to us, and we'll have Dirk answer them. And I just really want to thank Nelson, Levine, DeLuca, and Hamilton as well for, helping us set up this webinar today. We're also going to have Bob Bambino get on, and he's going to be discussing a little bit on more the risk management point of view for any of you guys that also have more questions towards those lines. So I'll take any questions now. I'll give you guys about a minute to click the chat button.
Dirk, this is Bob Bambino. I have a question for you. In terms of supervising off-campus drinking, say in town, for example, what are some practical ways that could be done, and what would your suggestions be?
Dirk?
Can you hear me?
Oh, sorry, we lost you for a minute.
As we saw from that prior case, the argument was that the university could have or should have been aware. So checking police blotters, I've seen things in other cases where universities actually would develop relationships with vendors of alcohol, so to speak, in the adjacent areas. And if someone would come in that looked suspect, they could actually email them copies of their ID, just things along those lines, and that goes more towards just trying to coordinate and show that you are making attempts. But I think those are two good ones, you know, checking police blotters and developing relationships with vendors of alcohol, which sometimes can be challenging because they're trying to make as much profit as possible. But if you try to work out some relationship with them where they're tipping you off or at least making you aware of potential large purchases of alcohol or attempted purchases by underage students, that's certainly some good ideas.
And Dirk, do you believe that the alcohol policies on campus should extend to all aspects of a student's life, including off-campus drinking?
Well, I mean, there's two answers to that. You know, one, I think certainly if we're looking at it specifically from trying to protect students and put them in the safest possible environment, the studies, the statistics that are out there clearly show that that reduces the likelihood. So the answer would be yes from that perspective. The caveat to that, or the warning, would be that if you do make that decision or that determination to adopt a policy that all-encompassing, it goes back to the whole theme of this presentation, that you're assuming these duties, and that if you're going to do that, you better have some type of policies or procedures in place to at least show that you're attempting to monitor that off campuses in all aspects of the students' lives, and you're making some effort to make sure that the students are adhering to that policy. And if you're not, if you're simply adopting that policy and doing nothing else, it's potentially very problematic from a legal perspective if anything bad happens.
Okay. All right, let's go over to Bob.
Okay, and thank you once again, Dirk, for doing this. This slide here is by no means a scientific evaluation of campus life. It's just some comments that we receive from our loss prevention specialists who visit colleges and universities on a daily basis. And I think some of their observations tie into what Dirk has been talking about over the past hour. Overall, there is an awareness on behalf of college and university administration that alcohol consumption is a problem. We often see alcohol prohibitions in the dormitories. We also see in different locations an indication that alcohol is permitted in adult housing or in adult dormitories. The next two kind of hit a point that Dirk had talked about before, and that's the idea that when alcohol is served on campus, there is often inconsistent age or identification verification, and there's an inconsistent enforcement of rules. And I think this goes back to some of the issues we talked about before, particularly with some problems regarding RAs, alcohol monitors, or then just general difficulties with students who are assigned the task of checking IDs. Dirk had talked about the McClure case a little while ago. We often see or hear of incidents where the alcohol enforcement or ID checks in town is lax or in some cases non-existent. Turnaround drinking was also talked about in one of his cases, I think two of them, where students leave campus, go off campus, consume alcohol, and then come back in an intoxicated or impaired condition. The Furek case that Dirk talked about directly related to Greek hazing, and we see and we hear of issues regarding alcohol-related Greek hazing. It seems that in the locations we visit, that alcohol consumption or prohibitions are discussed at orientation, and they're also mentioned within student handbooks. So some suggestions here when alcohol consumption is permitted, for example, at a university-sponsored fundraiser or at a party. Some ideas that the wait staff needs to be trained. This was touched on before. It doesn't necessarily have to be through a third party. If the university has a good alcohol control and service training program, that's perfectly fine. A cash bar, I think given human nature, will always restrict the amount of alcohol that most people consume. Some people have adopted a 2-ticket or 2-drink maximum. Limiting bar hours is a good idea. Closing the bar an hour or so before the event is over kind of follows what Major League Baseball does in terms of alcohol consumption stopping before the 9th inning. having a formal ID check policy, serving food helps, and then best, in some cases, are incidents where the college does not necessarily sponsor the event, for example, for a retirement party or a party involving the promotion of a staff member where people go off campus and celebrate that. It's not university sponsored. And the opportunity to attach liability to the institution is limited, not eliminated, but limited. And then lastly, just to, I think, reinforce one of the major themes that was presented throughout this webinar, is that if you're going to establish rules, they have to be enforced and monitored.
Well, thank you so much, Bob, for that. Does anybody have any questions at all? If you do, please click your chat button, and we can take any questions for Bob. Or Dirk, if you still have questions for Dirk as well. I'm also going to lay out the groundwork that this presentation is going to be available to all the attendees today and to people who didn't attend. I will send out another invitation at the end of this that will include the PowerPoint presentation and the link to the webinar on our website that you can download. I have been recording the entire webinar, so you'll have access to that. You will be able to send it to anybody that was unable. It'll also be on our Facebook and our LinkedIn page as well. So any questions? Okay. Thank you, everyone, and we will be in touch, and we welcome you all to contact us in the future, the Wright Insurance Group, Wright Specialty. We're very happy that you guys came and attended this. We thought it was a really great topic, and we're happy that Dirk and Bob were able to discuss it with us today.